Check one, check two, check.
Welcome to Thinking Through Law, the podcast that delves into the fundamental questions shaping our legal systems. In today's episode, we're tackling a long-debated topic. Is law truly an autonomous discipline, operating independently from other fields of knowledge? Historically, the idea that law stands apart, a self-contained system of rules and reasoning, has held considerable sway. Our previous conversations have touched upon this, noting that for a long time, legal scholars and practitioners believed that a deep understanding of law could be achieved primarily through the study of legal texts and the cultivation of legal reasoning skills. As Stephen L. Schwarcz notes in his introduction, the very question, is law an autonomous discipline, suggests this has been a central inquiry in legal thought. Think back to the traditional image of a lawyer or judge, steeped in case law, meticulously interpreting statutes and precedents. This image reflects a belief that the tools and knowledge necessary for navigating the complexities of the legal world reside within the legal discipline itself. Richard Posner, in his article The Decline of Law as an Autonomous Discipline, 1962 to 1987, highlights this historical perspective. He mentions figures like Langdell, who in the 1870s argued that legal principles could be inferred solely from judicial opinions, making the core of legal training the reading and comparing of these opinions. This was seen as a scientific approach, albeit one Posner characterizes as a form of Platonism. Lawyers, Posner notes, have historically used this idea of autonomy to protect their monopoly in legal representation. However, even in the past, this view wasn't without its critics. Justice Holmes, as we discussed, famously argued that law is a tool for achieving social ends, suggesting that understanding law necessitates an understanding of social conditions. He even envisioned a future where economists and statisticians would play a significant role in legal studies. Yet, as Posner points out, for a significant period, the focus remained heavily on internal legal sources. The prevailing belief, especially in prominent institutions like Harvard Law School, was that the essential knowledge for legal scholars came from authoritative legal texts. While law was acknowledged as a form of social control, the necessary understanding of society was often considered common sense or something gained through legal practice. But the landscape of legal thought has shifted dramatically, particularly in the latter half of the 20th century. Richard Posner compellingly argues that the faith in law's autonomy has significantly declined. He identifies several key factors that have contributed to this change. One crucial factor is the shattering of political consensus. Posner observes that the relatively narrow range of political opinion in law schools around 1960 has since exploded into a much wider spectrum of ideologies. This ideological diversity means that legal problems are now often approached with vastly different underlying assumptions and values. As Posner states, if equally distinguished legal thinkers can arrive at completely incompatible solutions to the same legal problem, it suggests that legal knowledge alone may not provide definitive answers. Moreover, many fields of law today are deeply intertwined with politically contentious issues. Secondly, Posner emphasizes the rise of complementary disciplines, most notably economics and philosophy. Economics, he argues, has become more rigorous and expanded its scope to analyze non-market behavior, covering areas directly relevant to law, such as crime, accidents, and property rights. The increased empirical focus of economics has also provided new ways to analyze legal issues. Simultaneously, the revival of moral and political philosophy has offered philosophical perspectives on fundamental legal debates, from capital punishment to rights related to abortion and poverty. Posner also notes the growing influence of public choice theory, game theory, statistical theory, and even literary criticism in legal analysis. Stephen Schwartz's introduction also hints at the increasing relevance of social and psychological issues to the complexities of modern law. A third significant factor, according to Posner, is the collapse of confidence in lawyers' sole ability to reform the legal system. He points to several examples of legal reforms in areas like bankruptcy, tort liability, and environmental regulation that have had unintended or negative consequences. These outcomes have undermined the belief that lawyers, operating within an autonomous legal framework, can effectively address all the challenges facing the legal system. Furthermore, Posner discusses internal developments within legal scholarship. The desire for innovation and the increasing prestige of scientific inquiry have pushed legal scholars to look beyond traditional doctrinal analysis and incorporate insights and methodologies from other disciplines. Purely verbal legal scholarship, which ignores the insights of other fields, is increasingly seen as less relevant in today's intellectual climate. Finally, Posner highlights the increasing importance of statutes and the Constitution as sources of law, compared to common law. Interpreting these often unclear texts requires skills beyond the traditional case law analysis that formed the core of legal training. Posner critiques the earlier, perhaps overly optimistic views on statutory interpretation, noting that factors like the breakdown of political consensus and the growth of social choice theory have revealed the inherent difficulties in this task. So, what are the implications of this acknowledged interdisciplinary nature of law? Posner offers several suggestions. He argues for a more prominent role for economists, statisticians, and other social scientists in legal reform efforts. He also calls for a more candid approach in legal scholarship and judicial opinions, one that acknowledges the political dimensions of legal issues and engages with the realistic premises of decision-making. He even suggests a new style of judicial opinion writing that moves away from overly formalistic justifications. Posner further advocates for law schools to encourage legal theory as a distinct field that studies law from the outside, using the methods of scientific and humanistic inquiry. This suggests a move towards a more integrated understanding of law within the broader context of human behavior and social structures. Ultimately, both Schwartz's initial question and Posner's detailed analysis point to a crucial realization: law does not exist in a vacuum. While it possesses its own unique methodologies and body of knowledge, its effectiveness and our understanding of it are deeply intertwined with insights from other disciplines. The challenges of a complex world demand a more holistic approach, one that recognizes the limitations of a purely autonomous legal reasoning and embraces the valuable contributions of social sciences and humanities. Thank you for joining us on Thinking Through Law. We encourage you to reflect on this discussion about the autonomy of law and consider how interdisciplinary perspectives can enrich our understanding of legal issues. Join us next time as we explore another facet of the ever-evolving world of law. Outro music fades out.